I'm going to find you guilty of counts 1, 2, and 3. And I understand that the state is asking for a cap of 7, but I understand the trauma you've gone through, and you can't go undo that. You can never get your childhood back. And who knows, maybe you would have been a different person if none of that had happened. All right, on this one, here's my question. Was there an actual plea entered on this case or not?
There was in front of Judge Angel.
All right. And the reason why I say that is because it doesn't say how the defendant pled. So did he enter a plea of no contest or guilty or what? All right. We're going to go on the record. The court is calling 2023 CR 5683 State of Texas versus Alvin James Mendoza. Could I have parties announced for the record for the state?
Miranda Correa of the state of Texas.
Defense?
Defendant Navy for the defendant, Your Honor.
All right. And are you Mr. Mendoza?
Yes, ma'am.
All right. You entered a plea of no contest on October 19th. According to the plea bargain agreement, punishment is to be assessed at a cap of 7 years. The state is proceeding on counts 1 through 3. They waived count 4. The fine is to be assessed at $1,000. The state is opposing your application, and there's to be Chapter 62 compliance. Have both parties had a chance to review the PSI report, state?
Yes, Your Honor.
Defense?
Yes, Judge, I have.
Any objections to the PSI report, state?
No, Your Honor.
Defense?
The only thing I would say, Judge, is he's also eligible for deferred adjudication. I saw the probation said he would be eligible for probation. I'll be asking for deferred.
Okay. Any witnesses, state?
No, Your Honor, just argument.
Defense?
Just the defendant, Your Honor.
All right. Could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right. You can lower your hand, and if you'll state your name for the record, please.
Alvin James Mendoza.
All right. Defense?
Thank you, Judge. Mr. Mendoza, before we discuss other factors in your life and your childhood, do you take full responsibility for what you've been charged with here?
Yes, sir.
Okay. Is there any excuse for your actions?
No, sir, there is no excuse.
Okay. You apologize to this court, and did you at the time to the investigators when you were arrested?
Yes, sir. I apologize to all the victims included in my case.
Okay, so you're aware that this is
I'm sorry. He said including.
Oh, and all the victims included in my case.
Okay.
Okay, so you are aware that this is not a victimless crime, even though some people might try to view it that way. You understand that it's not.
Yes, sir.
Okay. I'd like to discuss your childhood. So who did you grow up with in your household?
My mom and partially my stepdad.
Okay. Did you have any brothers and sisters?
Yes, sir. I have one brother and one sister.
Okay. And are you the oldest?
Yes, sir.
And your mother, she's now deceased, is that correct?
Yes, sir.
How old were you when she died?
I was 14.
You were 14 years old when she died?
Yes, sir.
And did you know your biological father at all?
No, sir.
Okay, when did your stepdad come into your life?
Roughly when I was about, I'd say maybe 3 or 4.
Okay, and then were you, before you were arrested, were you in contact with him, or had that kind of dropped off?
Dropped off.
Right, so you were no longer in contact with him.
Yes, sir.
Did anything happen to you when you were a child? Were you abused?
Yes, sir.
Okay. Without getting into specifics, how old were you when that started?
Age 9.
Okay. So you were 9 years old. Do you remember what grade you were in?
4th, 5th grade, maybe in 2.
And how long did that continue?
So I was 11.
Okay. Who was the person that perpetrated that abuse?
My stepfather's brother.
Okay. And just generally, was that sexual abuse?
Yes, sir.
Okay. How did it end? Like, how did that come to an end and stop happening?
My mother got in contact with my stepdad and his brother, and came to an agreement that he would never step foot near us again.
So do you know if it was ever reported to the police?
No, sir, not to my knowledge.
Okay, so you never talked to a police officer or investigator or anything like that when you were a kid?
No, sir.
Okay. Were you ever able to go to therapy or see a counselor for that?
No, sir, apart from the school counselor,
And when you say apart from the school counselor, how did that come?
I had spoken to my school counselor when I was in middle school, and it didn't have a positive outcome. This was after my mom had passed away when I was like after roughly about maybe 6 months, and the outcome was that there was a child protective services case opened, and my uncle got involved, and he did not have a positive outlook after that. By uncle, I mean my mom's brother.
Was he actually upset that you had said something?
Yes,
And why was he upset?
he was upset because it endangered his. It had opened up a case and endangered him with his son.
Okay, so that basically he was investigated for neglectful supervision. Is that
Yes,
correct? Okay. So the first time you tell anybody other than your mother about this, it's a very poor reaction and nothing really comes about. Is that fair to say? Now, how old were you when you first searched for pornography?
11 years old.
Okay. And you would agree that that was well before you were mature enough or ready to understand what that was all about.
Yes,
And do you believe that that came about at an earlier age due to the abuse that you suffered?
yes,
Okay. And so you've never really had a chance to process what happened to you with any counseling or therapy to this day. Is that correct?
yes, sir.
And so after your mother died, what was your living situation?
I had lived with my uncle, my mom's brother, and after it was born, more or less a downward spiral of things. We had no utilities at point at some point, saying my mind was more on financial rather than going to school.
Okay, did you start working?
Yes, sir. Started working at 16.
And where did you work?
Restaurants.
And is that before your arrest, were you working in a restaurant as well?
Yes, sir.
So basically from age 16 to before you were arrested, you were working in restaurants.
Yes, sir.
And was your salary essentially going to help with the household and utilities and bills for you and your brothers and sisters and the living situation? So the money you were making was not just for you to do whatever to support your family. Still a minor.
Yes, sir.
Okay. If the judge were to give you some form of community supervision, meaning probation or deferred adjudication, would you be willing to do any counseling, therapy, or other conditions that Judge Boyd requires of you?
Yes, sir. I would be willingly to be able to follow all of those any stipulations that I'm given regarding counseling classes or
And community service or
community services.
anything else?
Yes, sir.
And you would agree to any restrictions on any sort of devices or electronics, is that correct?
Yes, sir. Fully.
And you actually indicated to me that you wanted therapy, you wanted some sort of somebody to talk to because you've never had a chance to process what happened to you. Is that fair to say? Okay. And what if you were to get deferred adjudication or probation, what plans do you have in the future?
My plans are to get a small business degree and open up a food shop and also become a culinary expert.
And now, after you were arrested, you were interviewed by law enforcement, correct?
Yes, sir.
And you cooperated with them fully, is that true?
Yes, sir.
And you gave them the details of your online account so that they could assume your online identity, is that correct?
Yes, sir.
And the purpose of that was to grant them access so that they could investigate anyone who was distributing or possessing child pornography, is that correct?
Briefly on this. Mr. Mendoza, how old are you today?
I'm 22 years old.
So is it fair to say that although you may have not had a full understanding of what you were looking at when you started looking at this type of material at 11. At some point, you knew that you were looking at something you shouldn't have been looking at, correct? And unfortunately, it sounds like you have firsthand knowledge of what these children you were looking at were going through. Is that right? And even still, you not only viewed these images or searched for these images, you were sharing these images and trading them. Is that right? Did the PSI say that you had a fiance? How old is she?
She's 17.
She's 17. So she's underage currently, is that right?
I would object, Judge, to that question. 17's.
All right, 17 is the age of consent, so.
When did you begin dating her?
Roughly about a year ago.
Okay, and she was 16 and you were 21, more or less, is that?
Yes, ma'am.
I don't have any further questions then.
All right, any follow-up?
Just a bit of clarification, Judge. Where does your girlfriend live, her fiance?
New Mexico.
Okay. And how many times have you been out to see her?
Once.
Just once. Okay. And were her parents aware of this the entire time?
Yes, sir.
They actually chaperoned you when you went to visit her, is that correct?
Yes, sir. Fully supervised.
And so they were with you at all times, and at no point were you alone with her, is that true?
Yes, sir.
Okay. And they actually approve of your relationship, isn't that true?
Yes, sir.
Okay. At no point did they ever say, hey, we don't want you around our daughter or anything like that.
So they're not, you know.
Okay, so with full knowledge, they accept you.
Yes, sir.
And even her parents have kept in contact with you since your incarceration. Is that true?
Yes, sir.
That's it.
I have no further questions, Ron.
How did you meet her?
I met her online.
Okay. No, any other follow-up?
Argument now.
All right, court will hear argument. State, what are you requesting?
Judge, the state is requesting that you meet the cap of 7 years in this case. To point out a couple of things, the defendant was already given the benefit of some waived counts, and as well as, the cap and the ability to apply. Having reviewed the PSI report, although Mr. Mendoza does today apologize for what he did and state that he takes responsibility, it doesn't appear to me that full responsibility was taken. It sounds as though he would like to blame outside influences on why he did what he did. However, as you can see from the discovery and from the testimony, this was not just some searching of images or some viewing of images. It was storing of images, it was uploading of images, and it was trading of images for more images. I don't think that we know, the court knows that every person that's sexually abused does not begin trading, viewing child pornography. This is not as simple as a viewing of a few images. Also, I noticed in the pre-sentence investigation report, when discussing drug abuse issues, and it appeared as though Mr. Mendoza had stated that in spite of negative impacts on his jobs and his ability to maintain jobs and attend jobs, he continued to do the drugs. That appears to me like someone who's not as willing to make a change in their life for the better when they're doing something that they know they should not be. He himself, based on his prior experience, should, as a child, which is unfortunate because that shouldn't happen to anyone, he should know firsthand what these children are going through, and in my opinion, should have been even more sensitive to those types of images rather than using them or blaming his childhood as why he's viewing those images. Further, Your Honor, I know this is not part of the case, and her parents may be fully aware and okay with this relationship, but I do think that it is concerning that on top of viewing and trading child pornography, he is meeting someone who was at the time when they met underage online, may not have interacted with her in person a lot, but clearly have a relationship strong enough to have apparently proposed to her, someone younger than him who may be now of age at age 17. But I do think that that's something else that we should be concerned with going forward in the future. And so because of that, I don't feel this is a case that's good for probation, and I would be asking for prison time.
All right.
Thank you,
Defense.
Judge. I'm going to be asking for deferred adjudication, Judge. When we're talking about deferred adjudication for regular probation, I think the most damning aspect of this is the fact that he's going to have to register as a sex offender for the rest of his life. As we know, deferred in a case like this is not really like a deferred in any other sort of case, Judge. Just the mere fact that he's going to be registering as a sex offender for the rest of his life is going to be far more punishment than being a convicted felon. It's going to be a scarlet letter that follows him around for the rest of his life. Sending him to prison is not going to make anyone safer in this situation, Judge. Obviously, he has unresolved trauma, and even in the PSI, I believe it was on a scale of 1 to 10 for some child trauma scale. They said he was a 9 out of 10. So he did have a very traumatic childhood, you know, as the state acquiesces to and agrees to. I'm not a psychiatrist, Judge. I can't say for certain why he's in the position that he is. Nobody can. I can't. The state can't. He's not saying, and he's never said that this is exactly why he's made the decisions to land himself in this position, but we can't ignore it, and I think it has to be some sort of a factor. He's, like I said, him going to prison is not going to make anybody safer. He's a very young man. He was just, you know, he was just a few years when this investigation started from actually being a minor himself. I believe he was 19 or 20 years old. And so even if you gave him the max and the cap, he's still going to be a young man when he gets out. And he's not going to have addressed anything in his past to become a better person. I think what he needs, and is absolutely willing to do it, is any sort of the standard counseling that they have, any sort of therapy, Judge, to process the trauma that he went through as a child and understand the decisions and steps that led him to this position. And he's never said that that was exactly why it happened or that that's an excuse, but I do believe it's a factor that's mitigating and does need to be considered in this situation. He cooperated fully with law enforcement, Judge. I would take it as a grain of salt. Anything in the PSI that appears to be Mr. Mendoza minimizing his guilt, and because there is that bit on the PSI that says this is just a summary, this is not a word for word situation. Every time I've met with Mr. Mendoza, he's never minimized his guilt in any form, and his plan is not to minimize it here with you today. Like I said, he cooperated with law enfortement. He gave them all the credentials to his online accounts so that they could assume them for further investigations. Because of that, Judge, his childhood, his remorse, and I believe that it would be the best outcome for society if he is actually able to process that, understand the decisions that led him to be in this position, become a better person. Like I said, whether it's prison time or probation, he's still going to be basically a young man with most of his life in front of him whenever that comes about. So we're asking for deferred adjudication, and actually my client prepared a statement for the court if you would give him the opportunity to read that to you.
Sure. Any objections?
No.
Honorable Judge Boyd, today I approach your sound with utmost respect and remorse for my actions. As of November 5th, 2023, I have been incarcerated for 7 months in the Bear County Adult Detention Center. Since my incarceration, I have learned the strict understanding of the severity of my case and have been physically harmed 3 times since. I have grown terrified of being in jail and fear prison would be worse on my mind and my life. My childhood has been stripped away from me since I was age 9, and I would require counseling because I never got to talk about it and feel that this is why I made my mistakes. So I come before the courts respectfully asking for your consideration and granting me probation and not prison. My family and I agree that I may need the maximum probation allowed and a 180-day sanction with limitations on what I can do. Given my record, I will be a model probation, attending all classes assigned in order to become a successful member of society. I will never be the same mentally after my incarceration. I will never return to the mistakes I have made. My goals going forward in life are to be a culinary expert and chef and get a small business degree to own a food truck/restaurant. I am not a burden to my community. I am a taxpayer, and prior to my arrest, I was an assistant manager at my local restaurant. I have a family wishing for my safe return home without bodily injuries. So in conclusion, the granted probation by you, Judge, you will witness that you are not going to be making any mistake. I am in full agreement for mental therapy/counseling classes and other stipulations that may be added, but they will be followed to the T and fulfilled with great expectation. Thank you, Judge, for listening to my statement.
All right, thank you. All right, Mr. Mendoza, I want you to know that I always read everything. I'm not the one who accepted this plea, but I did read over the stipulations and everything, and I have listened to the argument of your attorney, listened to the argument of the state, and understand your trauma and what you've gone through. And I'm sorry that you've gone through that. I'm a firm believer that when people go to do their time, be it at the Bexar County Jail or if it's at prison, they should not be subjected to violence, because the answering for those charges are what happens in court. The prison is just the conclusion or the result of that, where you do your time. And people should leave people alone, and people should not be attacking people at the Bexar County Jail or at the prison. People should be able to go to the prison, go to the jail, do their time in peace, and hopefully learn what their triggers are, hopefully address the traumas that are in their life. But the problem is when people go to the Bexar County Jail and when people go to prison, everybody, well, not everybody, some people are at the jail and at the prison dealing with their own traumas, and their own traumas present themselves in attacking other people. It presents themselves in not knowing the normal way that things should run in society, or the helpful way that things should run in society. Then you have some people who are at the jail, some people are at the prison. They're just people who sole entertainment in life, their sole purpose that they see in life is just to prey upon others. I wish that when I would send people to prison and I would send the people to the Bexar County Jail, that they would get a chance to reflect on why they're there and reflect on bettering themselves and not having to reflect on watching their back. My concern in your case is the trading. That's a problem. So I'm going to deny your application. I'm going to find you guilty of counts 1, 2, and 3. And I understand that the state is asking for a cap of 7, but I understand the trauma you've gone through, and you can't go undo that. You can never get your childhood back. And who knows, maybe you would have been a different person if none of that had happened. But I'm taking that in consideration with sentencing you, okay? All right, so the court will sentence you to 6 years in each count. The counts are to run concurrently. There's Chapter 62 compliance. And I'm going to ask that at the prison, they place you in the mental health unit. They do have persons that will help you with your mental health. They do have persons that will help you with the therapeutic community. I'll request for the therapeutic community as well, but I don't know if you're going to qualify for that. Even though I'm requesting that in my judgment, in my order, you're still going to have to ask for it. You understand? If you do not ask for it, they're definitely not going to consider it. And it's just going to be like, I never ordered it. Okay. All right. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes,
all right. Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you. You're welcome.
Thank you, Ms. Davis.
Yes, thank you. Christopher De La Garza. And then after that, it will be David Quinones. And then Jesus Lopez. Court is calling 2021 CR 9806, State of Texas versus David Quinones the second. Could I have parties announced for the record for the state?
Jason Garrett, for the state, Your Honor.
Brian Kimbrough from the news.
Are you Mr. Quinones?
Yes, Your Honor.
All right, I'm gonna show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you have a chance to review that with your attorney? Did you understand it?
I did, Your Honor.
Are you the same David Quinones the second who was placed on deferred adjudication in 2021 CR 9806 for the offense of aggravated assault with a deadly weapon on November 16, 2022 for a period of 8 years? Is that you?
That is me, Your Honor.
All right, state.
Yes, Your Honor. Violated condition number 2 on or about the 28th day of April 2023 in Bexar County, Texas. The defendant David Quinones II did then there legally use a controlled substance, namely methamphetamine, in violation of condition number 2.
How do you plead to that? True or not true?
It's true, Your Honor.
Waive the remaining violated conditions, Your Honor.
Any objections? Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 2?
I do, Your Honor.
Court will find violation of condition number 2 true. Is there a proposed agreement?
There is, Your Honor. And the recommendation for under probation is also the same, to deny the motion to move adjudication of guilt and continue the individual on his deferred, and to have him enter the DDRF followed by outpatient and 180 days in sober home.
Is that what you're asking the court to do, defense?
It is, Your Honor.
All right, Mr. Candace, you want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do, Your Honor.
All right, you can lower your hand, state your name for the record.
David Quinones II.
All right, Mr. Candace, why are you not being successful on this probation? And here you are back on the same day that I gave you probation, the 16th. So why are you not doing what you're supposed to do?
I don't have any valid excuses. I've been doing the best that I can out there, and I'm in a lot of the wrong places. I didn't pay my phone bill. I didn't have the available open opportunity for probation to contact me. And that's my fault. That's why I wasn't able to follow some of the conditions. But it's not something that I wish to continue doing. I just want the opportunity to be able to make this right. And
Well, this is a case where the state wanted you to go to prison, and your previous attorney brought me medical issues concerning you, mental health issues concerning you. So I'm the one who gave you deferred. And instead, what you're doing is using drugs. And then I even tried to address the mental health issue, and I'm not taking it as true, but we're trying to get to the bottom of what's going on with him. I even had you go to the mental health initiative, and you're not doing that. You're doing nothing. You're just coming to me with your hat in your hand and saying, please don't revoke me. So I don't understand how things would be differently if I were to follow the agreement and not revoke you. So what are you doing?
I'm just trying to do the best that I can out there, and
But what does that mean?
I've had a unstable home environment, and I haven't been home as often because it hasn't been a very positive place to be.
Okay, well, how old are you?
36 years old.
All right, who are you living with?
My father.
All right, so obviously, maybe your father doesn't want you there, or you don't want to be there because you don't think it's the best environment. Am I right in that?
You're right in the fact that I don't want to be there. It's just there's drug usage in the house, and I don't want to get in trouble for that.
Okay, so why don't you have a place of your own?
I'm on disability. They take child support out. I'm not making enough per month to support myself.
Okay. Probation? I don't know what we can do with Mr. Quinones. Where is he going to be living? I mean, I know everybody said sober home, but
So I know that that was a recommendation, and I had spoken with defense counsel about it. I mean, he would have to, for the sober living environment, I mean, that is something that is also requires payment, and it's like a rent. You have to rent a room. So I mean, there's the financial obligation for that as well.
So does anybody know how much that costs?
I think it varies per house. So he has to, I had explained that they have to kind of apply to enter the sober living home. And then the sober living home has to be willing to accept him as a resident.
Well, will Lifetime accept him?
I believe that they will accept him. I know that we had talked about some medical issues that he has. And so I had explained, you know, even in an inpatient setting, I don't know what his medical limitations are,
Mhm.
but we can certainly try Lifetime Recovery. And then maybe while he's transitioning out of Lifetime, maybe give him a referral to the reentry center, or maybe even recommend him to felony drug court.
All right.
That's another option that would have a lot of more frequent contact with him and some case management services.
All right. So I'll deny the motion, alter main conditions, and it's to be Lifetime Recovery, followed by a referral to felony drug court with their dual diagnosis program. Is there anything else?
Nothing in the state, Your Honor.
No, Your Honor. Is there a lifetime recovery? Does that involve a process? And
Yes, and they will actually transport him from the Bear County Jail.
that's fine.
All right. Is there anything else you need from the court to be successful?
No, Your Honor.
All right, we can go off the record from here on out. You need to get in touch with your probation officer. You just can't be out here on probation and not really on probation because you're not doing anything. Otherwise, you could potentially be going to prison for 20 years. You understand?
I do, Your Honor.
All right, good luck to you.
Thank you, Your Honor.
You're welcome. Court is calling 2023 CR 7902, State of Texas versus Leonard Johnson. Can I have parties announced for the record for the state? Defense?
Cornelius Cox.
And are you Mr. Johnson?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Mr. Johnson, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor, save for the fact that we'll be waiving and abandoning the enhancement.
Any objection? Mr. Johnson, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with aggravated assault with a deadly weapon? Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Johnson, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 4 years in the prison. There are no applications. There's an affirmative finding of family violence. There's to be no contact with Barbara Ann Nichols Duncan. Did you understand that to be the plea?
Yes, ma'am.
Did you understand with the affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with the affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
Did you understand that to be the entirety of the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State.
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
Sorry.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Yes, Your Honor. State offers states 1 and attachments.
No objection.
Mr. Johnson, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would calling the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. State, have you talked to the complainant?
I have, Your Honor.
And is she aware of this?
She is, Your Honor.
And is she in agreement with this?
She is, Your Honor.
All right, defense, anything you wish to say on behalf of your client?
Oh, no, Your Honor. Just say the court followed the plea agreement.
All right, the court will find you guilty, sentence you to 4 years in the prison, give you credit for any time served. There's an affirmative finding of family violence. There's an affirmative finding of a deadly weapon. There's to be no contact with Barbara Ann Nichols Duncan. Going to show you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Do not come back here again for this nonsense. Do you understand?
Yeah.
She does not want to be with you. And again, I'm going to tell you this. If somebody has a new boyfriend, a girlfriend, that means that they don't want you. Or if it means that, oh, I still want you, but I want my boyfriend or my girlfriend as well, you have 2 choices. Either accept it or say this relationship is over. You don't get violent. You understand?
Yeah.
All right, good luck to you. All right, and what is the discovery issue?
The discovery issue relates to the medical file of the complaining witness at the VA hospital. And I filed motions to cover my bases. We can have the argument of whether or not the state has an obligation to get this under Brady and Big Window, but the long story short is that the VA requires a order from the court to release that information. So I was cutting out the middleman by including that.
All right, so this is what we're going to do. We're going to bring this back on November 30th.
Okay.
And at that time, I'll give you a jury trial setting. And at that time, we'll see where we are on the medical records.
Okay.
So state, if you can see, if you all have that, or if you all are going to object to this, then we'll take.
Yeah, I mean, if it's in our possession, we'll turn it over. If it's not, I don't think we're required to go and find it.
All right, so on November 30th, we're going to come back, and on that date, you will get your trial setting date, and we'll take up the issue of this discovery matter.
Okay. I guess I would ask the court if they could rule on, or if they could order.
Well, here's the thing. I know you want to cut out the middleman, but I like to do things where it's done as quickly as possible. Guess what? If the state has this, and we're very crowded in court today, if they have this, they're going to give it to you. So there's no need for this.
My understanding is they don't have it. It's in the possession of the VA hospital.
Well, let's find out.
Oh.
We'll find out. So we'll come back on November 30th.
All right. Thank you, Judge.
Who's the attorney for Annette Drago?
That's me, Your Honor.
All right, today an offer was due. Has an offer been tendered?
It has, Your Honor. And what I would like to do is get a plea deadline date for her to consider it. And then we can come back and tell you if it's going to be a plea or a trial.
All right, on Annette Drago, can you recall that back on the 30th as well? All right, your plea deadline date is going to be November 30th. At that time, you'll need to let the court know whether or not you're accepting the offer. Do you understand?
Yes, ma'am.
Your Honor,
Yes.
I'm real sorry, but can we do it either 27, 20, 29, just because I'll be in Colorado.
Oh, what are you doing in Colorado?
Like every year I take my kid to Breckenridge with my wife.
All right, we'll put it on the, 28th.
Perfect. Thank you very much.
And then before you leave, Dinah's thinking about that. So if you can tell her what you all do in Colorado.
I will. Yeah,
All right, thank you.
a lot of fun. Do sleigh rides and stuff. Really, it's fun.
Yeah, she wants to know where to go and what to see.
Okay.
All right, then with that, you're excused.
Thank you, ma'am.
All right, court is calling 2023 CR 8385, State of Texas versus Kevin Owens. Can I have parties announced for the record for the state?
Jason Garahan, you're on.
Defense?
Orlando Castañon.
All right, the court is in receipt of a request to allow Mr. Owens to travel on November 20th to Sustainable Staffing located at 8008 West Avenue, Suite 2, from 8:30 a.m. to 3 p.m. for a job interview, and also to travel for a job fair on November 29th, 2023 at Southeast Education Center, 5230 Eisenhower Road, San Antonio, Texas, 78218 from 10 a.m. to 2 p.m. State, do you have any objections?
No, John.
All right,
Thank
it will be allowed. And once you sign the reset form,
Yes, Judge.
you're excused.
Okay.